I'd like now to welcome our first panel of the day on cryptocurrency litigation, who will be moderated by my partner, Stephen. Please come.
Well, good morning, everyone. Glad to see everybody could make it here, notwithstanding the strike. I joked, I flew in from Washington yesterday, and it took me almost as long to get from Heathrow here as it did for me to fly across the Atlantic from DC. So, congrats. So, our topic today in this panel is cryptocurrency litigation and funding. Now, somebody remarked when I spoke with them a moment ago that obviously, given my gray beard, I didn't start out doing crypto litigation. I confess that that's true. I spent a good part of my career suing insurance companies for corporate policyholders, and I still do some of that. I got interested in crypto in about 2015 while working on software, and became interested in a dispute resolution platform, and somehow that changed my focus from suing insurance companies to crypto. There are through lines, of course, which is finding simplicity in a morass of words. I still think that that's true if one is trying to understand this stuff. Usually Occam's razor applies. The simple answer is usually the correct one. In a moment, I'm going to ask our panelists to introduce themselves. I'm just curious. I do this when I talk about crypto. I've been doing this since about 2016, giving presentations. How many people here understand what a blockchain is? Can you raise your hand? Okay, that's not bad. That's not bad. How many people here know what Bitcoin is or understand what Bitcoin is? That's pretty good. How many people own Bitcoin? Okay, so you violated the fundamental rule of Bitcoin. You're not, the entire audience, you should have kept your hands down. You had it, but you lost it in a boating accident. So what's amazing to me as a litigator is I looked at Law 360 this morning. I get an alert on my phone. Law 360 FinTech. It was all about crypto. Now, bear in mind that the Bitcoin white paper came out in 2009. And in about circa 2018 to 19, I wrote a weekly blog post with another lawyer in the US called Crypto Case Law Minute, where we would write a little squib on new cases, and it was actually hard to find them. I remember using Westlaw to search for Ethereum in 2018, and I couldn't find any cases. Well, it has certainly changed, and it's changed really quickly. So what we're going to talk about, what we'll do is, first I'd like our panelists to introduce themselves. They'll tell you a little bit about themselves and their practice focus, and then we'll get right into it. So we'll start to my right.
Morning all, I'm James Collins. I'm a commercial barrister. I've been doing that for longer than I will own up to. I'm relatively late to the crypto game. I have to admit, when I first heard of Bitcoin, I thought of it as a kind of snake oil. But there's nothing like work in a field to convert you. I'm not yet sufficiently converted to accept payment in anything other than fiat. But I did dabble myself, and I'm glad to say I've made more money doing crypto cases than I've lost investing in crypto. And cases recently I've seen from one extreme, I'm involved in FTX, and at the other extreme, I've done a case between two individuals just doing peer-to-peer transactions and arguing about Tezos, which I'd never heard of even before I started that case. That's probably enough from me.
I'm Simon Greaves. I'm a partner at BDO, and I lead a practice there that does quantitative risk and valuation analysis. So our involvement in crypto has come very much from a valuation of crypto assets. I'm actually the opposite of him. It is snake oil. I call them assets because they're not assets. But valuation of derivatives on crypto, which is quite interesting, quite challenging. And I was actually speaking with a colleague of mine yesterday about this, and he believes, a bit like you, James, really, he thinks it's great, and it's got real value to it, and you can really kind of fundamentally understand what drives crypto. So it'd be interesting to see where this panel goes on that one, because it's not my view.
Hi there, my name's Sam Goodman. I am also a barrister at 20 Essex. I put my hand up to confess owning some Bitcoin. It turns out I'm a better lawyer than I am an investor. That did not go fantastically well. I was one of the authors of the UK Jurisdiction Task Force, very exciting name, legal statement on crypto assets, which was one of the first examinations of how English law would apply to crypto assets. It's been adopted by courts since as being accurate, and I act in a number of cryptocurrency cases. Current one that's quite a lot of fun is a case for 3 high net worth individuals who had about $100 million worth of crypto assets in an exchange, and their case is that the exchange said to them, you can have, they froze their assets and said you can have them back, but you guys have to take a 60% haircut on your assets, which they say they're forced to do, and are suing the exchange for the sort of $50–60 million of losses that they suffered. And I maybe am somewhere in between the two of you in terms of my overall outlook on crypto.
Thanks. My name is Yoav Navon. I'm the co-founder and chief investment officer at Nemesis. We are a litigation funding firm that deals only with crypto-related matters. We are pretty new, but I'm being involved in this industry for almost 5 years now, doing a lot of, opened the first branch ever in Israel with a litigation funding firm, Woodford, dealt a lot with IP litigation at the days. Roughly a year ago, I wanted to start my own fund, and the funding market has become pretty big. Needed to find a niche that is growing, that requires a deep understanding, and there is a little competition. Back in the days, 3AC and Celsius just collapsed, so definitely crypto was the obvious choice. Found the great partner that understands crypto a lot, and we established that a few weeks after FTX collapsed, so it's only validate our choice, and definitely seeing exciting things ahead of us.
So let me ask, you said, I think it was Simon, you said you're convinced it's snake oil. I guess I'll ask each of the individual panelists, from the standpoint of either litigating cases or funding them, does it matter if it's snake oil?
The answer, if I start, do you want to start, Simon?
No, you can
Okay,
go ahead on that one.
The answer is, obviously yes. And obviously, if you're going to fund litigation, what you want to know is you're going to have an asset at the end, or a pot of gold at the end of the rainbow that you're actually going to be able to convert into cash or into something that is tradable and valuable. And with some of these cryptocurrencies, I would say are definitely snake oil. At the other extreme, you have digital assets that are firmly linked to real-world contracts or real-world assets, which you should be able to convert into something valuable relatively easily. And so if you're going to fund some litigation, I'm sure all you litigation funders probably know this better than I do, the first thing you want to do is look at the defendant and the assets. Am I going to be able to get recovery from either?
I would reiterate the point about recovery, which is the absolutely biggest issue I think people face with anything crypto related. In terms of does it matter if it's snake oil, I kind of get the point that you have, so-called stable coins, which for those who don't know what stable coins are, they're sort of allegedly linked to a fiat currency. But I kind of class those as a little bit of snake oil as well, because with other types of crypto, they might be stable, but we've just seen in USD coin, for example, it lost basically all of its value when it transpired that they held lots of cash at SVB. So what does it mean by being stable? I think it's a bit sort of Emperor's New Clothes, if you ask me. So, but I also reiterate what James is saying, that I think one of the biggest issues is that, coming at it from a valuation perspective, is how on earth do you know what it's going to be worth at the point at which you reach recovery? Because litigation, as you all know, can go on for many years, and if it suddenly starts off being 100 million of Bitcoin, for example, what on earth is Bitcoin going to be in 3 years' time? Will it exist in 3 years' time? So I think that's, I agree with you there, James. That's
Let me challenge you, though. Isn't that the same issue if you're thinking about recovering equity, recovering debt. You
no.
don't know what the value is going to be. In
No,
several years.
it's fundamentally different, and it's fundamentally different because of fundamentals. So if I'm valuing an equity, there are fundamental things that make that equity move in value. So it's a real thing. So if it's Microsoft, right? It's a real company with real people selling real products. There's actually something there you can analyze. And also, if you look at the movement in what I'll class as real assets, they follow a fundamental pattern. So the way that interest rates behave, they have a pattern that's called mean reversion, but it basically means they come back to where they started from. Equity have a standard way that they drift upwards. And so there are fundamental patterns to real asset classes that just don't manifest themselves in even things like Ethereum and Bitcoin, where people pretend that they're analyzing how it's moved over time. And they're flipping a coin. You might as well go to the casino in Monte Carlo.
Sam, looks like you have something to say about that.
There are very many cases in this space that do not, where what you're seeking is not necessarily the recovery of a specific crypto asset, that they are called crypto cases because they are broadly in that sphere, but actually they're an arbitration between shareholders about the joint venture that set up an exchange, or you've suffered some huge trading loss and actually it's the intermediary that you're suing. So it matters if you're after the asset itself. But I think that you don't have to go very far down the list of crypto assets by market cap before you get into a territory where there are genuine concerns that the people behind the crypto asset are pulling the strings and are sort of running a kind of private asset where they're bumping the prices at their own whim. So there is some danger there, though I think that with the sort of top 3, 4, 5 assets, there is a sufficient degree of certainty that you can predict where the asset is roughly going to be at the end of your litigation. Obviously, this is a space where there's market events that catch you by surprise, but there is now an increasing level of stability, I think, particularly when prices have been so low for so long, that some people say the only way there is upside.
Yoav?
Yeah, taking back to your questions, what's the difference between litigating and funding? So very much depends on the jurisdiction, but eventually when there is more risk alignment between the parties, obviously the gaps will be smaller. But if you need to only fund legal fees, then you have to evaluate it, obviously, and look at it more carefully. For the underlying assets, from the funder perspective, obviously, we don't want to take risk and we try to be very conservative. So we always look at cases in which we know there's going to be either fiat money at the end of it, or that it's a coin that we can trust, which is effectively Bitcoin and Ether. And even then, we will take a significant discount on the current pricing to evaluate what will be the price at the end of it. We need to decline a lot of great cases on the merit side because we just cannot trust the underlying assets when it's a coin that we don't know where it's going to be evolved in the next years, and what's the project, I would say, whether we can trust it and whether it's going to be subject to some kind of investigation in the future. So we try to be very careful, and definitely for us as a funder, that's the key for every case we look at.
James, talk about some of the, you might not be able to talk about the actual clients, of course, but talk about some of the claims that you're seeing or that you've dealt with. Are they contract claims, tort claims, legal, equitable? What are sort of the buckets of claims that you're seeing?
Well, so one of the big issues is precisely that, what sort of claim is it? So with FTX, you would have thought everyone should know what their rights were, but they don't, and that's going to be one of the big disputes that has to be resolved over the next few months. They're actually claiming some of the people who have digital assets on the FTX exchange. They're claiming both legal and equitable ownership of those assets. So a bit like you put a watch in storage. They're saying that actually belongs to me. Now that's difficult when it's a completely fungible asset that's been mixed with a whole lot of others and in many cases has disappeared from the account you put it into. So one question is, do you have legal ownership? Then another argument is, do you have some equitable interest in whatever balance is left in those particular wallets? And when all that fails, you're left with your private personal claims against the exchange or against the individual with whom you've traded. And those can be in contract or in tort. So actually, I think that we're going to see claims that cover pretty much every area of law, save perhaps trespass, that we're used to working in.
Maybe trespass too, actually.
Yeah, who
In fact,
knows?
I had a case in federal court. That's one of the interesting issues I find. One of the things I like about this space is that it's new stuff, but how many folks here are attorneys, barristers or solicitors, I guess you call them here. So one of the cool things is it's this brand new asset class, right? And we have clients who say, change the world, it's totally different, it's a new paradigm. I've yet to find a judge who said, yeah, I don't get it, right? The United States is a common law jurisdiction like England and Wales, and judges, they look at bigger categories of ways of thinking of things and then narrow down. I'm reminded of there's a great case from the early 19th century, late 19th century in Tennessee. And in that case, the issue was, who was responsible for the death of a child who was electrocuted by an overhead power line? Was it the power plant? Was it the contractor who owned the poles? Was it the company who hung the line? And the court, this is a 130-year-old, 140-year-old case. The Tennessee Supreme Court said, well, we've never seen this set of facts before, but we're lawyers, we're judges, we'll figure it out. And they did, and they applied existing precedent and found, I think they said that the power plant was liable, which was probably a bad result, and they were reversed 40 years later by another Tennessee Supreme Court. But that's what is interesting here. Saying, are you, Sam or James, have you followed the tulip trading case?
Yes, I was involved in that at an earlier stage of it. So
are you able to talk about it?
I can, a little bit.
All right, so this is an interesting example, and I think it's important if you're a funder or you're a lawyer, you're thinking about taking on a case, the question of whether or not you think this is snake oil or not, what are the claims, what's the recovery look like? So why don't you tell folks about tulip trading, what's the issue there?
It fits within, I guess, the broader category of claims. It's the category I'd probably do most of is asset recovery. So there has been a fraud, and somebody, I guess, from a funding perspective, may not have the funds to pursue the assets. And so there's sort of, at the moment, there's three routes that you pursue. One is obviously going after the bad guys, and we can talk about the challenges of that later, but also the opportunities that are there. Another is suing your intermediary, your exchange. And in tulip trading, the third route that's being plotted is to sue the developers of the cryptocurrency. And in very broad terms, the claimant there says that they had been the victim of a very large fraud where a very significant amount of Bitcoin and other currencies had been stolen from them. And they're suing the developers of of a number of cryptocurrencies, saying essentially that you owe me as a holder of a crypto asset a fiduciary duty, and that requires you to do lots of things. But the main thing is to implement some sort of patch in the code that reverses the effect of the unlawful transfer. And obviously, if a claimant can get that kind of relief, then assets back into their hands. But it's obviously hugely controversial. There's lots of issues. The developers of these cryptocurrencies are sort of an amorphous collection of individuals dotted across numerous jurisdictions. And so, as you can imagine, it's being very heavily fought. And in this jurisdiction, first instance court said, threw it out, said absolutely no serious issue to be tried even, that the developers owe these fiduciary duties to the owners of crypto assets. And one of the interesting points that the court said, well, what are these developers supposed to do? They might have a judgment from Court A and a judgment from Court B, and this is just some teenager sat in front of a computer. It's somewhere in the world. How's he supposed to, or she's supposed to deal with that? The Court of Appeal, who considered it very recently, said no, there is at least a serious issue to be tried that these duties might exist, and so has sent it back for a trial, which will be very, very interesting. But it's one of the ways, I think, in this space that innovative thinking is being applied to find ways around the asset recovery problem that exists with these assets. Now, whether it is ultimately going to be successful or not remains to be seen. But that's the broad outline of what's going on.
And to be clear, it's a couple £100 million that's at issue, right?
Yeah, maybe more actually.
Maybe more.
It's
interesting you think about it. If you think about the way something like Bitcoin works, you've got open source software developers who live all around the world. You've got miners who have a choice as to whether or not software should be used. And this It was Craig Wright is the plaintiff. Mr. Wright also claims to be the inventor of Bitcoin, which is something that I think many people are skeptical about. But setting that aside, what he's saying is, I lost my money. You all, who wrote the software, you're fiduciaries. Now, I think the fiduciary law is very similar here as in the United States. As lawyers, we're fiduciaries, right? You have to, as a lawyer, as a fiduciary, you have to put your own interests above those of your client. It would certainly be a novel application of law to say that open source software developers have that obligation, but that's where we are. I don't know, Sam, if you had, not Sam, excuse me, James, if you had something to add to that.
Certainly none of my crypto cases or digital asset cases have involved those sort of concerns, so probably not.
I mean, it's interesting too, like from a funding standpoint, I scratch my head and think, I believe that I know how the case is being funded. I think it's being paid for by a business colleague or associate of Mr. Wright. But does that sound like, is that something that strikes you as fundable, Yoav? That sort of claim? How would you do the math? How would you figure it out?
Well, again, it all depends on what's the underlying assets. Sometimes you can add a monetary value to it or to attach it to it. When you need to assess, obviously, you try to look at the valuation of the digital asset at the day when it occurs, and even then to take a significant discount. Obviously, there's always theories about how you can increase that, but we try to be very conservative when we look at that.
Who were the, sort of from a buckets of claimant standpoint, who are the types of plaintiffs you're seeing, James? Are they institutions, individuals, traders? What are the types of people we're seeing who are bringing claims?
So in my experience, it's individuals, either sort of one-off, where somebody's traded with another individual and hasn't got their crypto back or whatever they're complaining about, or groups of individuals who will group together to make claims against the exchanges. Obviously, if you're taking on someone like FTX, you're unlikely to be able to afford it on your own. So it makes much more sense to group together with the thousands or tens of thousands of other people who have lost money.
Is there, and you'll forgive me, as an American, class action practice is obviously huge in the United States. Do you think that's a direction that we will see grow in England and Wales, collective action? I know that's something that has, I know that it does exist now, but it's not as developed.
It's not as developed, and I haven't really thought about it. So my involvement in FTX springs out of the US class action.
Sam?
In terms of claimants, a lot are individuals, obviously high net worth individuals for types of cases that we do. I've done a fair few cases for exchanges themselves or tech companies whose founders think or thought that cryptocurrencies were a great idea. And so as a result, large amounts of the company's reserves or their own personal reserves but often the companies are held in crypto. And they are, exchanges are often targeted for hacks and lose a lot of money that way, as do the owners of tech companies. So there is a full spectrum, and also one area as well in which I've crossed over into recently, I'm not sure whether I'll go back, is into high net worth divorce, where there are real issues with spouses, usually there's, in my experience, it's wives who are alleging that husbands have got some early trading experience of crypto and that they're hiding really significant amounts of assets, but the family solicitors, not an insult, they just don't have the experience of dealing with sort of complex asset recovery cases or dealing with cryptocurrency. And so there's increasingly a market, and often they don't have the funding to pursue the investigations that are necessary to uncover what's there. So I think there's going to be a growing market for that type of claimant as well.
I've seen some of that in the U.S. as well, been brought in as the crypto person. What are some of the challenges in those types of cases?
They are, I mean, it's there, I think, it's more of a challenge of, I was talking to James about this earlier, it's perhaps more of a challenge of style, that as sort of civil fraud litigators handle cases very differently to the way that they do in the family division, and their understanding of the asset class is behind ours. Obviously they will catch up, but the judges as well haven't dealt with as many of the cases, there's not the same sorts of orders that the commercial court judges are used to making in respect of crypto assets. So it's starting everything from first principle again and explaining it to judges and creating precedents, which obviously creates unpredictability, but also opportunity.
And how do you, I mean, the issue that I faced, and I had a similar case in New York about 2 years ago. One of the issues that I had was, well, you're in a divorce, wife and the husband don't necessarily trust each other. How do you deal with the question of finding assets or assuring the other side that all assets have been disclosed? I don't know if that's something that, Simon, you deal with in your practice or others do at BDO.
And we have an asset recovery group, but that's not really... I've been single joint expert in matrimonial cases, and they are, as honestly, from an expert perspective, they're not pleasant to do, because you end up being in the middle of two bickering people, which is not terribly a pleasant place to be, if I'm honest.
Well, I mean, it seems like one of the, maybe this is a challenge for all crypto cases if you're a plaintiff. How do you know what the quantum of potentially recoverable assets are? So if you have if you're talking about dollars or pounds, you can send, in the United States, you can send garnishment interrogatories to banks, right? You can do, do debtors exams, depositions, and so forth. With crypto, it's different though, right?
Well, we in this jurisdiction, we've developed a fairly novel solution to that. So for those of us who are acting in these cases a few years ago, the problem is you obviously don't know in an asset recovery case who's defrauded you. You need to find out their identity. What's unique about crypto cases is that, of course, looking at the public blockchain, you can see where the misappropriated assets have gone, but that means that you can see some sort of string of numbers and letters that they've been sent to, not that any real-world identity. So generally the approach of our judges and our sort of law reforming bodies has been very, very pro-victim over the last few years, and very keen in making this a jurisdiction that people want to litigate their cryptocurrency disputes. So the latest innovation is sounds dull, but is incredibly impactful, is a new gateway for service out of the jurisdiction. I, along with somebody else in my chambers, drafted this new gateway that allows the English court to make orders against exchanges located outside the jurisdiction. So incredibly wide-ranging power, and it's being used, I've used it in a case already, where you can approach 8, 9, 10 exchanges located in Cayman, Hong Kong, Mauritius, wherever they are, the US, obtain these orders and require them to disclose who their account holders are, i.e. the real world names, their KYC AML info, and also the account balances of any accounts that they hold at the exchange, which gives you, it redresses this imbalance of information, and it gives you a platform then to immediately freeze the assets if there are assets there. You can do it at the same time, or you can wait to find out what's actually in the accounts. But that innovation, I think, has massively changed the balance for fraud claimants in this jurisdiction.
I mean, is that something that you could do in cases just involving cash, or you're dealing with a brokerage account or bank, or is it only with crypto?
Yeah, no. So it's the detail of the gateway probably isn't necessary, but the main point is that it's cases where you have a proprietary claim. So it doesn't matter if the property you're after is cash or Bitcoin or an artwork. The requirement is it's not a purely personal claim for damages, that you're after some specific property. There's obviously some slight quirks to that, but broadly that's how it works. So you can use it for cash too.
And have you found courts in other countries, or have you found, exchange in other countries, have they complied with those orders?
Yeah, that was one of the criticisms at the time of drafting this. Everybody said, well, what's the point? Because you're going to serve these orders out from an English judge, and everyone's going to say, well, that's extremely interesting. Well, they're either not going to open the email, or they're not monitoring their contact form, because of course
I'm actually wondering what I have represented some exchange clients, and I'm actually wondering, it's interesting, like what would the advice be?
Yeah.
There's sort of countervailing interest that an exchange may have an obligation to protect the identity of its customers, and then the question is, if you're an exchange in the United States, you receive an order from an English court, maybe you require that it be registered in the United States, or that you go through, I guess it wouldn't be an MLAT because you're not a state actor, but...
So we have had some unhappiness from US parties who have received these orders, and it is, I mean, there's two points to make. The first is that the orders say that 3 points. Firstly, the compliance levels that I've seen have been very high. People comply with them, even if they feel maybe they don't, under their local law, have to. They tend to comply. Not everybody, but it's a pretty high rate. Secondly, the reason why they comply is because it is said to them, that's fine, you don't have to comply, but if your directors come into London, you'll be arrested and sent to prison for 2 years. And that generates compliance quite quickly. And thirdly, the orders say that nothing in the order requires you to do anything which would break your local law. So there is that safeguard. So you might need to override your client confidentiality provisions, but you don't have to commit a terrible data crime to comply with the order.
And that's an interesting tool. I'm also like, there's another way that I think folks focus on in trying to identify assets, and I tell this is a true story. In the United States, there was a investigation. It was a serious drug investigation. The U.S. authorities were looking for someone who was the biggest methamphetamine supplier to the United States, operating on the dark web. And this person lived in France, came to the United States, I'm not joking, for a crazy beard contest in Texas. Big beard, down to like here. Was arrested at the border. He was the guy. You know how they found him? This is crazy. He didn't use good wallet hygiene. Now, when you create a public address to receive Bitcoin, it's a hash. It's a unique set of letters and numbers. It's the same thing with Ether and many other types of cryptocurrency. Good wallet hygiene or operational security would dictate that you don't reuse the same wallet address. Well, this moron, thankfully, he used the same address that he used on the dark web for an Instagram account. And, I don't know who it would be, it was Secret Service, DEA, whatever. They went on the internet, matched it. He's now serving 30 to life on my dime as a U.S. taxpayer in a not very nice federal prison. But, it's another way. The nice thing about blockchain from a recovery standpoint is you do have the blockchain. It's like a stock ticker. And if you stare at the numbers long enough, eventually, because to Simon's point, you can't really do much with crypto, eventually somebody will try and find a fiat off-ramp, an exchange, and remove it. I mean, I think that those are definitely things, that's definitely something about crypto that makes it easier. Another thing too, and maybe James, you can talk about this. One of the interesting things about blockchain is that it's everywhere, right? That's the concept. It's a distributed database. And what I like to think is that distributed presence equals distributed jurisdiction. So we had a case where somebody, for some reason, paid $700,000 for some NFT monkeys. And I spell monkey, in this case, M-O-N-K-E-E, not with a Y, because it's funny to me. Anyway, this guy, nice guy, a lawyer actually, spent $700,000 on some NFT monkeys. They got stolen. And they're now worth $50,000, which is also an interesting part of the story. What did we do? We sued the monkeys. It was an in rem case. And our theory was, because there are blockchain, actually this would have been, I think these were actually Solana. But because there were nodes everywhere, including on Long Island where the guy lived, we made the argument that we were able to sue the monkeys in rem there. And that's something that if you're using a centralized database, a centralized or traditional client server data structure, you're not able to do it. I don't know, have you seen that in England and Wales, the concept of in rem jurisdiction applied to crypto assets? Is that a thing?
Certainly seen it asserted.
Yeah.
In fact,
How's that gone?
Well, my first case was on the other side, saying there was no in rem claim, and thankfully for my client, we won. It's not the end of the case. So he still holds his cold wallet with a whole lot of Bitcoin on, and claims he can't remember the key that would enable him to open it. So it's a classic illustration of the dangers of this kind of litigation. You've got somebody with, I might suggest, a reasonably strong personal claim against my former client. that person has a cold wallet which the claimant can demonstrate has received a large amount of Bitcoin. But unless my former client actually gives up the key, the claim is going to be worthless. You're just going to end up with a data stick that's worth about $1.
Well, I mean, the answer to that is civil contempt, $5 wrench attack.
Yeah, yeah. There might be ways ultimately of getting the information, but in terms of one that was explored is how easy is it to hack, and even with really powerful computers, you're looking at years, absolutely years to get into these wallets.
Yeah, I mean that's one of the I would say one of the potential benefits. I'll disagree with Simon just a little bit. One of the benefits of Bitcoin is that it does, in theory, require state actor computational power to reverse transactions. It's an append-only database where you can't easily reverse transactions because of the way the blocks and the cryptography work. I want to pick on Yoav a little bit. Tell us all your secrets. What makes, in your view, what would make a crypto claim something that would be interesting to you, and what are some red flags on the other side, things that would make you say, nah?
Well, without putting all of our secret sauce out.
All the secrets.
Yeah.
Tell these nice people.
I could say that 80% of the way we underwrite cases, it's not much of a different from any other litigation funding underwriting process. That's the truth, for us anyway. We try not to pursue illegit entities that we don't know where they're going to end up in a few years. We try to make sure that our assets at the end of the road that we will be able to collect. Obviously, we need to have some deep understanding of what is crypto, and to understand the ecosystem and understand what is the underlying project was all about, whether it's legit, whether it's going to be subject to some regulatory matters. But in the end of the day, for us anyway, at this stage, we try to focus on cases that are straightforward, coming from all the major collapse that we are familiar with, that we can really have a good evaluation of the assets and what's the likelihood of the case to succeed. And jurisdictions, you've mentioned jurisdictions. Obviously, we need to understand which jurisdiction may be involved and how each one treats crypto matters. So as Sam noted, I think that the UK one is very developed, and we can trust things that come out of the UK at the moment more than any other jurisdiction in the world because of the clarity we see from precedents that are already being achieved. And if the case goes to, let's say, jurisdictions that are have less clarity about, Seychelles, Estonia, Malaysia, and stuff we see, there will be probably something that we will take a step back and not enter into.
I want to talk, it seems like it's kind of simple. One thing you need to think about is the value, right? The value of the asset, and cases can take years to resolve. Simon, from a valuation standpoint, how do you look at Bitcoin or Ether or some other cryptocurrency? How do you sort out the value? Or let me ask it differently. One of the challenges I've seen, and my lawyer brethren might be familiar with this here, is if you take an asset that was worth $1,000 when purchased, $2,000 at the time of a loss, but $50 now, how do you quantify the damages? And it's not just a question of, I think it's a question of how do you sort out what ultimately, let's assume you win, how do you decide what it's going to be worth?
There is a burgeoning sort of derivatives market in Bitcoin and Ethereum. That's a fact. Is it liquid? Not really. It's very thin, but you can kind of get some sort of visibility on where these things might be in a year's time, for example. but beyond that, it's quite difficult, and I think that's going to get better as we see. Goldman's is a good example of a major bank that's got into to set up a crypto desk. The spreads that they take on trades are eye-watering, so I wouldn't advise individuals doing a trade with Goldman. But that is starting to happen. So I think as more financial institutions get into that market, there will be greater ways of actually having a market that you can price forward. Because at the moment, if you look at the liquidity on some of the exchanges for some of the futures, for example, it goes out about 12 months, but you can only do small tickets on it. If you try to do 100 million, bang, it's gone. You wouldn't even get a price on it. It wouldn't happen. So it does present a very big issue, and because of the concerns about the way that crypto tokens behave, not following normal patterns of other financial assets, it means modelling that from a sort of a more mathematical perspective is quite challenging. So it comes back to really what you were saying, is you've got to say, okay, well, I can look forward a year, and that gives me some insight, so I can get some idea. I can then mathematically model forward, given the behaviour of this particular token and what I can observe from it. But then I'm going to whack on a massive liquidity discount because I've got no idea. So and that, where do you put that liquidity discount and that discount? It's what you can get away with. I think probably what you can get away with.
Here's what I'm thinking. I'm thinking about Credit Suisse and Silicon Valley Bank and whether those things were predictable a year ago. I'm not suggesting, believe me, that Ethereum is the same thing as the world's biggest bank, but is there something about that unpredictability that is actually all that different from the prediction that you have to do with traditional assets? I get it. Like, I know a bank is correlated to customers. A car company manufactures cars, but if I ask you to tell me what Bank of America is going to be worth in a year, aren't you also? You're doing this with a little math as well?
You are and you aren't. I mean, you aren't in the sense that there are fundamentals about Bank of America that you can model and you can understand. What you can never predict is fraud. Credit Suisse has got a lot of things in the press at the moment about what it's been doing, and it's not necessarily very savoury. So is it all to do with SVB, or is it to do with other things that have been going on at Credit Suisse and brushed under the carpet? So you could say the same thing about, was Lehman predictable? And there'd be some wisecracker who'll go, yeah, I predicted Lehman happening. No, you didn't, because nobody did, right?
Enron. So my first bonus as a lawyer, I thought it was so smart. I'd read an article in the New York Times Sunday magazine about Enron. I got like $1,000 for my first bonus. And I called my father-in-law as a stockbroker, and I said, Ron, I want you to put it in Enron. And he was a very sober Midwestern stockbroker. And he was like, are you sure? I was like, yeah, I know this. It's gone within 6 months. But I'm also curious, not just about prediction, but about valuation. And maybe this is for the lawyers, either Sam or James or both. I have seen this issue arise in cases where asset is purchased at X price, it's lost at Y price, the current market value is at Z price, below either. There's a methodology in the United States, I think it's maybe called the New York rule. There's some New York cases on how you do that. But how would you go about, if you were the plaintiff, how would you go about arguing for what the right amount is? Is it the price at purchase, the price at the time of loss, or the price at the time the damages are entered, or is it some other price?
I think we generally have pretty flexible rules. There's general rules of principle, but then the cases are littered with examples where judges will take a different date because that's the proper way of identifying the compensation for the loss that the party has suffered. And we've always been very flexible about that. For example, where there was a line of cases in I think the 80s or the 90s where these people were having these arguments about foreign currency, and by the time of judgment, the foreign currency had massively increased in value to a particular earlier date, and the English court said, well, we'll just give you the judgment in the foreign currency now then. You can have an order that somebody pay 10 million euros to you today. And I can't see any reason why, if that was the more advantageous route for the claimant, that they couldn't do the same thing with cryptocurrency. I don't think it's been done yet in this jurisdiction, but given that you can have judgment in foreign currency, I can't see in principle why couldn't occur with Bitcoin.
Wouldn't the defendant argue that that's a windfall of some kind? I mean, I would.
Yeah.
Why should I have to pay more than I stole?
Yeah. I mean, I guess it's you may end up looking at the likely behaviours of the claimant and what they would have done with the asset. Would they have kept it and cashed out at a high point? And in a circumstance, it depends what the defendant's done. But if they've been involved in fraud, then the claimant's going to have all the presumptions going in their favour as to what they would have done with the asset.
How do you look at it, James?
It's really just going to be the application of traditional rules that have been developed in the context of other asset classes and applying them to crypto and digital assets. I don't think it's going to have its own set of rules developed. So it might be, I mean, just think of a case I did where a work by Anish Kapoor that was in storage accidentally got put by the storage company into the dump because it was wrapped in plastic and they thought it was just plastic. and nobody knew about this for several years. And by the time it was discovered what had happened, works by Anish Kapoor were worth a lot more than they had been at the time that the particular sculpture was destroyed. And you just have a body of rules that say, well, on the facts of this case, do you look at the date that the property was taken, or do you account for subsequent changes in value? And I don't think that crypto or digital assets are really going to present any particularly unique problems that require the development of a different set of rules.
Just like the Tennessee Supreme Court in the electrocution case.
Yeah.
I have some more questions that I can ask, but we've got about 4 minutes left. I want to open it up to the audience if you have questions. Please go ahead, stand up and project.
I have a question exactly about what you just mentioned about that sculpture. Imagine you have two claimants.
Can you speak a little bit more loudly?
Sorry, I'll try.
Shout. Oh, there's a microphone.
So I'm Paul Dwayne of STR AI, a company based in Geneva. So I have a question precisely about what you mentioned last about that sculpture. The situation here is a little bit different though, because you might have, imagine you have multiple claimants who have a similar claim in a certain currency, and imagine one of them has all of their assets in that currency is involved in the lawsuit. And for the other claimant, it's only 1,000 of their assets in that currency. They have a very different perspective on the result, depending on which currency is used to assess the damage. Because basically, the conversion rate that you establish within the lawsuit is multiplied by 1,000 for one of them, and not for the other. So there is a viral effect in terms of their whole portfolio that is not present with the lawsuit around one specific sculpture.
So as Sam said, the rules here are pretty flexible. And one of the things you do is you look at what would the claimant have actually done if it had had that particular asset in its hands at that time. Rightfully, the courts are a little bit skeptical about claimants who come along and said, well, I would have invested in this share and sold it as it reached its peak the day before it collapsed in value. But although they're skeptical, the rules are still flexible and allow genuine claimants whose loss has been genuinely increased by their particular circumstances to recover that increased loss.
I would agree with James. As experts, we've quite often been asked to do that type of exercise where you say, well, what would have been the consequence of in your foreign exchange example? And going back to James's point, if somebody then claims, well, I'd have put it on, on some sort of high risk strategy, well, you wouldn't, because your overall strategy as a firm was to do something else. So it's really about matching what you would have done given your normal business behaviour. And as experts, we would say, okay, well, therefore it would have grown to X or it would have grown to Y based upon what you would have normally done, not what James was saying in terms of some sort of random high-risk strategy to try and get some more money out of the gig.
Sam, did you have anything you wanted to add to that?
No?
I mean, I've seen this a couple of times in cases in the United States. There's a case out of New York where what the court did was it used like a 3-month trailing average for the value, because part of the thinking is, well, we don't know the plaintiff. I like your concept of ordinary course, what would they have done? In that particular case, it wasn't clear whether or not the plaintiff would have actually, maybe the plaintiff would have liquidated it. And so the judge sought sort of a moving average is the way that it worked. Any other questions? I see one right there. Please stand up and shout. Oh, you'll get a microphone.
Hi, thanks. Tusha Patel, HFIM. Currently, the question I addressed to the panel is gathering evidence. What are the challenges of gathering evidence in this particular proof of the case, and what is good evidence compared to traditional kind of commercial fraud cases?
I'll take that one. They're the easiest fraud cases to gather evidence for you could possibly imagine. The merits are normally all in your client's favour. It's very unlikely somebody has you obviously keep your eyes open, but it's very unlikely someone has made up that they've lost a load of cryptocurrency. So you've got some evidence of a hack. In a case I did, it was because the particular company hadn't upgraded the firmware on its router, and that's how the hackers got in. So you have evidence of what happened, you have evidence of the loss, you have your blockchain showing you where the assets have gone, and you have defendants who are, in no case, and I've done a fair few of these, in no case have the defendants, the alleged fraudsters, actually shown up to fight it, because they take the same portfolio approach that you will probably do to these cases, which is to defraud lots of people and hope that a decent percentage, I'm not suggesting you defraud anybody, and you invest. But their approach is we'll make our investments, theirs are fraudulent, and some of them will come off. So they don't show up, so you have all the evidence you need, and actually in most of these cases, what you end up saying to the clients is let's go for summary judgment, which you get, and then you move straight to enforcement.
It looks like our time is up. Thank you so much. And thank you to the panelists.
Thank you.